does. Of course we do. I'm David Levy. If you think you also see me in the audience, that's my much older brother, John. And I'm president of the American Law Institute and at Duke. And this is not our first rodeo. I will be transparent about that. We've been together. We were at Duke at our Judicial Institute there to talk about Jeff's book, and it was so interesting. The bios of our panelists are in your book. I will just introduce them very briefly. Really an extraordinary group of people. So sitting right next to me is Judge Sutton, who's a member of the Council of the American Law Institute and a judge on the Sixth Circuit. He clerked for Justice Powell, as did I. Although not the same year, just a little bit younger. And he was the solicitor of Ohio, and that's, I think, maybe was what's sort of the origin of his extraordinary interest and obsession with state constitutions. And he's written this book, and here we are. And seated next to him is Judge Ide, Allison Ide of the 10th Circuit. Now you're going to see a pattern here. Judge Ide taught at the University of Colorado. She clerked for Clarence Thomas. She was the solicitor of Colorado. She served on the State Supreme Court of Colorado as a justice of that court, and then was recently appointed to the 10th Circuit. And seated next to her is Joan Larsen, a member of the American Law Institute, as is Allison, as are we all. And Joan taught at the University of Michigan Law School. I'm told a very fine institution.
Some say so.
Some say so.
There are those who love it.
There are those that love it. As Carl Llewellyn said, look at the wood. It's very beautiful. And he meant that actually quite sincerely. And Joan was a justice of the Michigan Supreme Court and now serves on the Sixth Circuit and is a colleague. But I think that means you can really let him have it.
Just go at him.
Yeah, just go at him. And then seated at the end is the formidable Goodwin Liu, who is a justice of the California Supreme Court, a member of our council, head of our executive committee, or projects committee, and has written widely, taught at the University of California at Berkeley Law School. We used to call that Bolt Hall. He clerked for Justice Ginsburg, and he's one of the great judicial intellectuals that we have. So Jeff, why don't you kick it off and take a few minutes to tell us why you decided to write this book and what's in the book, and then we'll try to attack it, support it, have an interesting conversation, and there'll be plenty of time for you to get into the act.
Thanks, David. When you write a book, you learn who your friends are. So thanks to you, ALI, and my friends up here on the panel. It's actually not a bad idea for ALI to be doing something about state constitutions. Hans Linde, emeritus council member, really got this going with a landmark article in 1970, and just about everything in the book grows out of that 1970 article. Much as I'd like to attach myself to Hans Linde, though, I must start by acknowledging some humbling realities about writing about state constitutions. So I'm at an event in Columbus about a year ago, and I run into a retired doctor friend of mine, Dr. Briggs, and he comes up to me with a lot of enthusiasm and says, Jeff, I understand you've written a book. That's so exciting. Is it an autobiography? And I said, no, it's not an autobiography. He said, well, is it a mystery? I love mysteries. And I said, well, Dick, no, it's not a mystery. And then a little frustrated, he said, what's it about? And then with much too much enthusiasm, I said, state constitutions. Well, poor Dick Briggs is a very polite guy and had no idea how to respond to that. And after a long, awkward silence, said, sure it's not a mystery. Second story's worse. I'm married to a 7th grade English teacher, and just as I was about ready to send the manuscript off to Oxford, I said, Peg, would you mind taking a look through this? I'm sure there's a lot of dangling participles and other grammatical problems. And so I give it to her on a Friday, and by Sunday, I see that she's only about a chapter and a half in, and I see, gee, Peg, I thought it was a little bit more of a page-turner. Then with way too much seriousness, she looks at me and says, Jeff, I do not love you that much. So, yeah, go out and get it. It's a great book. Let me go back to Dick Briggs, though, and organize my remarks around the mystery idea. There are several mysteries here, and mystery number one is, why would a federal judge care about state constitutions? I can make it worse. I've been a judge now for 16 years, and I've had just one state con law issue. So this is not something that overlaps with my work in one sense. The two basic reasons are, one, I don't think there is such a thing as exclusively federal con law, even though that's what all our casebooks, treatises would suggest. To me, the best way to understand it is as American constitutional law and as a dialogue between the state and federal courts with respect to the state and federal charters. So it's not just the story of Brown and the ending of Jim Crow in the South. A true understanding of equality in public schools would have Brown at one end and the Rodriguez story at the other bookend. Rodriguez, of course, is the case where the U.S. Supreme Court in a 5-4 decision rejected a claim to equality between rich and poor school districts. If you truly care about a fair shot in life, a fair start in life, you're not just going to want to eliminate race-based barriers to a good public education. You're going to want to eliminate wealth-based barriers to good public education. Rodriguez had a chance to do that. It did not. And what's interesting after 1973 is all the state legislators and state courts that filled that gap. Another story, another chapter in the book is something similar. It's kind of the anti-Brown story. So Brown, of course, is the greatest individual rights case in American history, at least in the courts. But it leads to, I would say, something of a myth that the U.S. Supreme Court always gets it right when it comes to rights protection. And one chapter in the book is about the eugenics movement, where the U.S. Supreme Court was very much on the wrong side of history when it comes to interpreting due process and equal protection. Most of you know about Oliver Wendell Holmes' infamous Buck versus Bell decision in 1927 with the infamous line, "3 generations of imbeciles are enough." What most Americans do not know, because our American con law stories do not teach us this, is that before 1927, there were 8 lower court cases, 6 in the state courts. 7 of the 8 cases get it right by the verdict of history, some under state constitutions, some under the federal constitution. Worst of all, after 1927, after the Buck versus Bell decision, many more states enact eugenics legislation, about another 12 to 15 more states, and the activity in the state courts stops. After 1927, of course, no state court could contradict Buck versus Bell when it comes to the meaning of the 14th Amendment, but nothing prohibited them from using their own state constitutions to eliminate these eugenics laws. So sometimes we place a little too much faith in the federal courts and in particular the U.S. Supreme Court and the U.S. Constitution. The second part of the mystery as to why a federal judge would care is I'm quite worried that the path the U.S. Supreme Court is on is a trajectory that's unsustainable and may well end in tears. From my first day of law school in 1987 to the present, I see a world in which we have rights escalation. One year it's red right, blue right, red right, blue right. In one sense, that's a wonderful trajectory because after all, I'm a federal judge, and how much fun to wake up in the morning and think of all the good I can do with the more power we have. The one small problem with this trajectory is that the American people, fools though they may be in the short term, have caught on to the power the court is exercising and of course want a say in who controls that court. You can't deal with U.S. Supreme Court decisions you don't like by amending the U.S. Constitution. That's not realistic with the 3/4 requirement for an amendment. So all of this energy, all of this concern about the power the U.S. Supreme Court is exercising is all being channeled quite intensely through the selection and confirmation process. The problem with that is that the American people eventually are going to perceive perfectly partisan votes for U.S. Supreme Court justices. We were just 2 votes away from a first in American history, a perfectly partisan vote for Justice Kavanaugh. 1 Democrat crossed the aisle, 1 Republican crossed the aisle. It seems inevitable We'll have an associate justice before long confirmed to the U.S. Supreme Court by a perfectly partisan vote. That's already happening in the lower courts. How can the American people not draw from that experience the lesson, this seems to look like just another political body? Add to that the reality that 5 out of the top 10 items, roughly, on both political parties' wish lists line up with issues at the U.S. Supreme Court, and it becomes very apparent that this is a very important body that to the average American is going to start to look like a political body, whether that's a fair judgment or not. The problem with that perception, true or not, is where does the U.S. Supreme Court have authority to perform its function of checking other political bodies is if it's perceived as just another political body? Why can it check a political president, a political Congress, a political state, if the American people perceive it as just another political body? One way or another, we need a détente at the U.S. Supreme Court, from my perspective. Détentes are not easy, and they're going to be particularly difficult in this country, which embraces judicially enforceable rights more than any other country in world history. The secret, to me, if there is a secret or a possible answer, is to have less immediate, at least, rights recognition at the U.S. Supreme Court, and have the state courts using state constitutions as the first responders when it comes to new rights issues, try to develop American con law from the bottom up as opposed to the top down, a little less of the winner-take-all rush to Washington, perhaps leading to situations where we have less rights recognition at the national level as an absolute matter, or if we're going to have rights recognition at the national level, perhaps a little more patience before it's done, which presumably will lead to less resentment with these winner-take-all rulings. So, mystery number 2. How did we lose track of state constitutions and state courts as potential first responders when it comes to protecting individual rights? It's really quite ironic. The rights we care the most about all originated in the state constitutions. The greatest era of constitution writing in this country, indeed in world history, is between 1776 and before the fabled summer of 1787. All of the individual rights provisions we care so much about, unreasonable search and seizure, free speech, free exercise, due process, all originated in the state constitutions, and for the first 150 years, roughly, of this country's history, we thought of the state courts as the first protectors and enforcers of those individual liberties. Third mystery, is it possible that American basketball players are smarter than American lawyers? Absolutely. As a former basketball player, I'm proud to say it. No American basketball player was ever awarded a 2-shot foul and took just one of the shots, particularly after missing the first shot. In American law, every day of the week, in every state in the country, we have American lawyers taking just one shot to protect their clients, that one shot being the federal constitutional shot. That's due to an education gap. I mean, there's a lot of chickens and eggs here as to how this happened. But the shocking reality is lawyers paid to protect their clients quite frequently are just taking one chance to protect those clients and their individual rights. And it is all about an education deficit when it comes to state constitutions, and I can prove that. No criminal defense lawyer faced with a Miranda-like problem or a map-like problem would just choose one or the other. All right, lawyers are not known for bringing too few arguments. I can promise you that as a judge. That has not been their problem. So if they've got a Fourth and a Fifth Amendment type problem, they're going to bring both. How is it when they have a search and seizure claim? Every state constitution in the country protects searches and seizures. How is it they're bringing just the federal search and seizure claim? I mean, that really is a mystery. The last mystery is, why is it so often the case that when the state courts get the second shot, the state constitutional shot, they start with the presumption that the meaning of the state guarantee is the same as the meaning as the federal guarantee? That is so odd, and let me illustrate it. Let's say I left my judgeship tomorrow and decided I would run for the Ohio legislature. In my first campaign speech, I'm up there and I get a great question from a citizen who says, "No, Jeff, you seem like a nice guy, and wouldn't it be bad to have a federal judge as a state legislator?" I'm not sure that's true, but they say that politely. And then they say, "Now, Jeff, what are you going to do the first time you face a really difficult problem you've never thought about before, and it's really quite challenging as a matter of policy making?" And what if my answer was, "My first question always will be, what would Congress do?" That's it. I'd be done. My career is over. One question, one answer, I'm toast. Now let's say instead I ran for governor. What are you going to do, Jeff, if you get a really difficult problem and you're not sure how to answer it? Oh, I'd ask what the President of the United States would do. Doubly done. Why is it that when state court judges, 90% of whom run for office, they don't get in trouble for presuming that the meaning of these independent sovereign guarantees starts with the federal Constitution, starts with what the people in Washington has said it should mean? So my last point is, what would be the benefit of all of this? It is so hard to get agreement on anything in American government today, but I'm pretty confident I could get agreement on this one virtue of American federalism, that if you've got a new social problem, data privacy, opioids, it's a very good idea to experiment with a smaller sample size rather than a bigger sample size. You don't conduct a new experiment on 325 million people, 51 jurisdictions at once. That is very high risk. There really has to be an emergency before anyone would sanely do that. That, of course, is adopting, embracing Justice Brandeis's wonderful insight that you use the states as laboratories of policy-making experimentation. Now, of course, Brandeis was referring to the legislatures as the laboratories of policy-making experimentation. Everything I'm saying can be wrapped up in this one point. Why are we not taking that analogy and doing the exact same thing with these epic constitutional debates? Use our state courts interpreting their state constitutions as laboratories of constitutional experimentation, getting the benefits of all 51 participants in terms of institutions in this very difficult process of figuring out what due process, equal protection mean. It's a very strange thing for us not to do. And perhaps the strangest thing, and I'll end it with this because I've got a couple people that have taught before, so I'm kind of sticking it to them in case you haven't noticed. What class on federal con law ever isn't 75% devoted to all the flaws people like me are making when it comes to interpreting the federal Constitution? What a nice little step to say, okay, don't do what Jeff Sutton did in construing the federal Constitution, and you don't have to. You can use the Ohio Constitution or the Arkansas Constitution and construe this general word on reasonable search and seizure, due process, equal protection, free speech, to have a different meaning, whether a meaning that is more protective or less protective. It doesn't matter.
Well, that was a great setup. The four areas in the book that you cover, just so our audience knows, is you cover the Fourth Amendment, the exclusionary rule, and then the sequel to the exclusionary rule, the good faith exception. You cover San Antonio Rodriguez, which you mentioned.
School funding.
The school funding. You cover the flag salute cases, which I don't think you mentioned, and then the eugenics cases as well. And there's a theme in there, which is to sort of show how the state courts were dealing with these issues. So why don't we go down to California here? And what I'm hearing Judge Sutton saying is that it would just be great if Goodwin Liu could be in the crosshairs for a while. How do you feel about that?
Not fair.
Well, you have to be careful what you wish for. I think that's the rejoinder to what Jeff just said. Thank you all for being here on the beautiful Sunday afternoon. The fact that you're not outside enjoying the beautiful day is really what makes ALI ALI. So you're all here. It's a pleasure to be here on this panel with such distinguished colleagues. It was fun to do this panel at Duke, which David so kindly invited us to do, and then here reprising it again. I thought I'd begin with just, there's so much to say about Jeff's book, and it's such a monumentally important accomplishment. Actually, it's stimulated so much discussion in legal circles throughout the country. But I thought I'd just begin with a little bit of orientation to state constitutions, since that's kind of what I do now. One of the reasons I think that state constitutions have been a bit of a backwater in legal education and then more generally in the profession is our general kind of unfamiliarity with these documents. What are they? What do they consist of? And then when you actually pick them up and read them, they're extremely disorienting because they're lengthy. They have all manner of provisions covering all manner of subjects. They don't read like, fundamental charters of great government and the like. I think it might be helpful to think of these provisions in state constitutions in 4 buckets, just to kind of keep us oriented. The first is, I think that a lot of state constitutions are frankly larded with provisions that read like code. They are basically statutes that have been elevated to a higher level in the hierarchy of laws. And of course, they get the status of the top rung of the hierarchy. But in the main, they are essentially things that deal with very specific matters. And in California, for example, you can pass a constitutional amendment by ballot with 50+1 vote, right? So they don't, these kinds of provisions, which are plentiful, I'll give you just, I have so many favorite examples of this, but Alabama has one called Amendment 492, which promotes the sale of catfish. Florida Constitution, Article 10, Section 21, the title of this provision is called Limiting Cruel and Inhumane Confinement of Pigs During Pregnancy. These are important matters, but they're not quite at the same level as sort of defining the 3 branches of government and the like. But you get the picture. So there's a lot of these kinds of things, and we ought to, I think of these as code, in essence. Second type of provision you might find in state constitutions are rights and structure provisions, the kinds that we think of as, John Marshall, it's a constitution we're expounding kind of stuff. Rights and structure provisions that are specific to that particular state. So, for example, in California, we have a constitution that defines a number of elected offices, including the Attorney General, the State Superintendent of Public Instruction, the Insurance Commissioner, whatever, who are all constitutional officers with their own sort of lines of authority directly to the electorate, right? So we don't have the notion of a unitary executive, as in the federal model. And so these are all constitutionally defined. So you have things like that. On the right side, you have a lot of interesting things in state constitutions: environmental rights, education rights, various social welfare rights, different elaborations of religious liberty rights. All of these are distinctive to the states and should be given constructions that are true to the particular state texts and histories that brought them into being, okay? Third, I think it's interesting, there are a number of provisions in state constitutions that are parallel, actually, to federal provisions, but have distinctive state histories. So one example of this is the trial by jury guarantee. There's a decision from the Maine Supreme Court that elaborates the history of the trial by jury guarantee to say that this covers misdemeanors. Which isn't true with respect to the federal history. So the federal provision has been read not to cover petty crimes, and the Maine Constitution, which derives from the Massachusetts Constitution originally, historically did. And so one has to be careful in reading even identical language to check the history of the provenance, in essence, of these terms to see what they meant from the point of view of the particular jurisdictions that use them. The fourth category, though, is the one I think that most concerns us with respect to Jeff's book. And that's where I want to put most of the emphasis. That is those provisions that have similar wording, sometimes identical wording, as in the federal, and no particularly distinctive state meaning. Which is to say, if you consult the text, you consult the history, you consult the ratification debates or whatever, you're not going to find a lot specific that's been said about the meaning, for example, of the search and seizure clause of most state constitutions as compared to the federal. That's because the search and seizure clause is all derived from the same intuition during the founding era, the notion of opposition to general warrants, the notion that this was a measure to protect, to some extent, people's privacies and homes from unwarranted invasion. Okay, so there, I think you have some interesting notions, and as well in the due process area, in the equal protection area, even the notion of equal protection of law, of the laws. I mean, California has such a clause in its constitution, but it's actually derived from the federal clause because it came into being, that language, equal protection of the laws, came into being only after the ratification of the 14th Amendment. So you have in a number of these provisions the kind of give and take between the state and the federal that is so characteristic of a federal system in which there is sharing and dialogue. And thus one would expect the meaning of these provisions to be elaborated through that same kind of dialogue. And I think that is really the distinctive contribution of Jeff's book, is to cause us to think about the elaboration. I love how he puts it, that the title of his book is the Making of American Constitutional Law. And normally when we teach constitutional law in law school, which I used to do for many years, it's titled constitutional law, but we really mean federal constitutional law. And if you want a picture of American constitutional law, it really is the synthesis. And I want to here draw a contrast to, in terms of what we're talking about, to what Justice Brennan taught us in his 1977 law review article, in which he urged state courts to, in essence, backfill on the mistakes made by the US Supreme Court in inadequately protecting individual rights. So Brennan's thesis was basically that the Supreme Court is starting to mess things up. Please, state courts throughout America, pick up the slack where the US Supreme Court has inadequately protected individual rights. And by the way, in his 16-page law review article, he cites 36 of his own dissents in individual rights cases, right? And he says, you know, this is where the real truth lies, right? So, so Justice Brennan had this notion of a kind of one-way ratchet where the Supreme Court would make mistakes, in his view, and the state courts would kind of correct these mistakes one by one, state by state. I think that's one plausible version, of course, of state constitutionalism. It does happen that, you know, in some sense, like the Buck versus Bell story, the flag salute story, fits this model that the Supreme Court didn't quite get it right in certain instances, and then there was a need for a corrective later on. But the more interesting story, it seems to me, are the stories where there is a gradual working out of the meaning of a constitutional right, such that what we think about when we think about state constitutionalism, we're thinking about it as a structural proposition about the pacing, the modulation, and the evolution of doctrinal change. So in this picture, it's not that the Supreme Court of the United States is the proper place to decide a particular issue at any given slice in time. It's that we have a federal system that enables us to test ideas, to build consensus, and to pace change in a way that gradually brings everyone along. And there's no better example of this, I think, in contemporary times than perhaps the same-sex marriage issue, which, you know, we can still debate whether or not there was enough debate, but there was substantial debate that happened in the state courts and throughout society, of course, but it was notable that both sides of the debate cited the fact that numerous state courts had weighed in, including my own court, had weighed in on this debate before the Supreme Court finally resolved it in 2015. That's a kind of model of development. And I will just end with 2 points. One distinctive point about that model is that when the state courts are interpreting the meaning of equal protection of the laws in a debate like that, they are not assigning a particular state-specific meaning to equal protection of the laws. They are participating in a broader fundamental debate about American values, American principles. When California has an equal protection clause problem, we are not elaborating equal protection, qua California. There is no California specific meaning of equal protection. We're reasoning from general principles. And we're hoping that that reasoning can inform other courts around the country. Take it or leave it. It's up to you, of course. But that's part of how ideas get put into play in a federal system. And the last point I'll end on is that Jeff mentioned Brown versus the Board of Education. It should be noted that Brown itself is an interesting case study in this dialogue between state and federal courts. How it's taught is not typically this way. The usual way of teaching it, as most textbooks do, is to plot Brown as the culmination of several higher education decisions that preceded it, that were decided by the federal court, by the U.S. Supreme Court and other federal courts, most notably Sweatt versus Painter in Texas, the McLaurin case in Oklahoma, the Gaines case in Missouri. So you have this kind of progression where segregation was intolerable, where there were not separate facility for qualified black students, and so it had to fall, and then finally that put so much pressure on the K-12 system that that had to fall as well. That's all true, but it should be noted that the genesis of the higher education strategy was a case called Pearson versus Murray in the state of Maryland, where the Maryland High Court, state court, held unconstitutional the segregated facility at the University of Maryland Law School, again, which excluded a qualified black applicant. This was one of Thurgood Marshall's first cases, 2 years out of law school, litigating it with Charles Hamilton Houston. That precedent by the Maryland State Court is what the U.S. Supreme Court cited when it finally decided the Missouri case, Gaines, in 1938. And then the Brown case itself, you remember, was actually 4 consolidated cases, 3 of which were from federal district courts in Virginia, South Carolina, and Kansas. The 4th case was from Delaware. In the 3 cases from district courts, those courts had all found different kinds of segregation to be invalid under separate but equal, but refused to order a desegregation remedy. Only the Delaware court, which was a state court proceeding, not only found unconstitutionality under separate but equal, but ordered an integration remedy because it decided that it could not wait, that we couldn't just simply wait for facilities to equalize and sort of wait and see, as the federal courts had ordered, but instead articulated the notion that the right to an equal education was a present right that had to be implemented now. And the schools could go on segregating and try to equalize things, but until it was equal, the students, the black plaintiffs, did not have to wait. So by the time the U.S. Supreme Court ordered the disposition in Brown in 1955, in that disposition, it reversed the 3 federal district courts and affirmed the 1 state high court. And I think that that in of itself should give us pause in thinking about the role of state courts and state constitutionalism in protecting individual rights.
Thank you. Goodwin, if I could, since you're our one state Supreme Court justice still, so Jeff makes the argument at one point, he didn't mention it yet today, but he makes the argument that because our state justices tend to be elected or retained, that they have greater legitimacy when they enter into these disputes which are policy-driven or normative. But on the flip side, they don't have the lifetime tenure, and it was not that long ago that the 3, I think, or 4 justices of the California Supreme Court were not retained, and it periodically this happens around the country, and it's upsetting to judges and those who care about judicial independence. What are your thoughts about that?
Yeah, I think that's a reality. Of course, in 2/3 or 3/4 of the states, you have elected judges, and I would say one has to look with a little nuance at the type of electoral pressure that is faced. So in California, I think we're very lucky to have probably the mildest form of electoral accountability. I have a 12-year term. and I'm subject to nonpartisan, uncontested retention elections. So on the ballot, it just says, should Goodwin Liu be appointed a justice of the California Supreme Court, yes or no, and that's it. And surprisingly, 2/3 of the people say yes, but that means 1/3 of the people still say no. And it's not really, I give you a statistic like that based on really nothing. No campaigning, no committee, no nothing. They don't even know who I am. That's just a baseline measure of, I guess, people's attitudes about judges. I will say that there's been some empirical research done on this question, and it is kind of mixed. When you look at the gay rights decisions, there, I think, is a decent argument to be said that the state courts were ahead of the curve on some of those issues. On criminal justice issues, I think there's opposing data that says when time comes closer to an election, the courts tend to render dispositions more unfriendly to defendants. I think it's very hard to generalize, though, and I would just say that the one thing I've observed through panels like this and just being in interaction with both state colleagues and federal colleagues is that at least at the appellate level, and I can't really comment about the trial level, but at least at the appellate level, professional norms about appellate judging matter a whole lot more than things like electoral pressure. There's just a community of people who define themselves as judges, and we kind of know the metes and bounds of our job. And the way we go about our job generally is, the same from case to case and from jurisdiction to jurisdiction. We have colleagues, our colleague Wallace Jefferson, was Chief Justice of the Texas Supreme Court. In Texas, they have contested elections, partisan, every 6 years. Now, I would be curious what his perspective is in terms of how that affects the job, but I have no doubt that Wallace did his job because he identifies himself as a judge in the way that you and I would think about how a judge should behave. And I think, if anything, that also is an interesting aspect of our judicial federalism, which is that when people are brought into dialogue with one another and speak the same language, the same professional ethic and norms emerge and kind of govern the appellate enterprise.
Thank you. So, Joan, Jeff wants to give the state courts a lot more work, it seems, and I just, you're not on the state court bench
Yeah,
any
so
longer.
I'm all for it.
You might have some views.
Yeah, so first of all, thank you very much for having me here. I have a lot of things to say in response to what has been said already, and also some thoughts about Jeff's terrific book, which really is a great book, and you should all go and read it. But before I talk about Jeff's book, I wanted to talk about a different book. And this book was published in 1868, and it was written by a justice of the Michigan Supreme Court and founding member of the Michigan Law Faculty in 1859, and that was a gentleman by the name of Thomas Cooley. Now, I was here about a month ago to give the inaugural Thomas M. Cooley lecture at Georgetown, and although I came from Michigan, I was on the Michigan Law Faculty and I was on the Michigan Supreme Court, I knew very little about Thomas Cooley, so I had to learn. And what Thomas Cooley was most famous for was his book, his treatise on constitutional limitations, which was published in 1868, and it is a very long book. I wish I had brought it with me, but it's big, and I wanted to not check my bag, so I didn't. But it is a very dense book. It is about I believe it is 631 pages long, and it was, in its time, the definitive work on American constitutional law. You will have to trust me on that. I could cite to you all of its glories, but it was the defining book on American constitutional law. 631 pages, of which 15 concern the U.S. Constitution. The remainder was all about state constitutional law. So I think that underscores Judge Sutton's point that somewhere along the way, we lost the state constitutions. Now, of course, Cooley's treatise on constitutional limitations was published in 1868. 1868, of course, is also the year in which the 14th Amendment was ratified, and so Cooley's treatise was a product of its time, right? So at that time, American constitutional law was probably 2% US constitutional law and 98% state constitutional law. Nonetheless, I think Judge Sutton is to be commended for asking us to think very hard about what happened in the intervening years and what we might do about it and what we want to do about it. To what extent do we want to resurrect the project of looking to state constitutions? Judge Sutton asks the question, well, why is it that state courts, when they interpret their state constitutions, tend to follow what the federal courts have said about a similar provision? And I think he makes a great point when he says that if he ran for the Ohio legislature, he would not first say, well, what would Congress do? If he ran for governor, and I'm hoping he's not thinking about doing either of these things because I very much value him as my colleague and I don't want you to go. I'm just saying that right now. But if he were to do that, I'm sure he would be quickly elected and he would not say, well, I'm the governor of Ohio now, so I'm going to just ask what would the president do. But I think there's an answer to why judges, when they interpret similar provisions of the state constitution, say, well, the first thing I'm going to do is ask, what would the US Supreme Court do? And that is because they are judges. This gets to what Justice Liu said, which is that there are certain professional norms that constrain what judges can do, and I think what we want them to do. So if you're looking at a text, and the text is the same text that exists in the United States Constitution, it is quite likely that when the United States Constitution borrowed those words from the pre-existing state constitutions, which as Judge Sutton's book says they did, that the US Constitution meant for it to have the meaning that it had in the state constitutions. And when the state constitutions then that came after the ratification of the US Constitution borrowed similar words, they probably meant them to have the same meaning. Otherwise, they would have just used different words, right? If you used the same words, you likely meant for them to mean the same thing. So that explains why there is a good deal of borrowing. We also have to acknowledge the fact that the US Supreme Court has incorporated most of the Bill of Rights against the states, and that incorporation is what they call jot for jot, meaning that the states can't do anything other than what the US Supreme Court has said unless they are going to be more protective. So to the extent that we might think that the United States Supreme Court has erred, if they erred by being too generous in their rights protection, there's nothing a state court can do about that. They are bound to enforce the US Constitution, the constitutional provision, jot for jot. So all that states can do is be more rights protective. So then the question is, well, how much room is there for state courts to operate? And I think that gets us into the question of interpretive method. So, and that is a question that Judge Sutton doesn't address in his book, and I think that is the real conversation that we need to be having about judges in America. I mean, I completely agree with what Judge Sutton says about the pressure that is being put on the United States Supreme Court these days. My mother, who was born in 1931, said to me when Justice Kennedy decided to resign, she said, she is not a lawyer, she was a school teacher, she lives in Iowa, you can get the picture, and she said to me, my goodness, a man wants to retire to spend some more time with his grandchildren, and this country is arming for war. And I thought, yeah, that's right. That is what has happened, and it is because we put an enormous amount of pressure on our judges in Washington. So Judge Sutton's approach is to diffuse the pressure, take some of the pressure off by devolving more opportunities to state judges. That's a classic federalism impulse. It has many merits. It would certainly take pressure off the federal stage, but I don't know that it would necessarily keep us from having 50 little civil wars, or 51, especially given that many state judges are elected. This gets me to the point that Justice Liu made. So I think part of the disconnect, both with respect to running for a state election, which I did, elections in Michigan for judge are contested elections. They aren't retention elections as in California. I was appointed and then immediately had to run the following year in a contested election. They are contested, you make a TV commercial, it is running a campaign. And the one thing that I always thought was unfortunate is people would ask, well, how do I learn about the judges? What should I do if I want to decide who would be a good judge? And the answer, I don't think, is, well, you should look at the judge's record and see who she voted for. Did her decisions come out more pro-labor or pro-union? Did they come out this way or that way in terms of which party won? Because that is not the test that I think judges take. So it's like being graded on a test I didn't take. Who won, the union or management? That's not the question I ask. The test I take is reading the text of the provision, right? Interpreting those words, reading the precedent, and that doesn't get communicated to the electorate. And I also think it doesn't get communicated very well, even through the appointment process. So I will give you an example. It doesn't come from the Michigan Constitution, but it had just as much effect, I think, in the press in Michigan anyway, as the Michigan constitutional question would have had. It was a statutory question, and the statutory question was, could you be arrested for driving drunk in your driveway? Okay, so this is a gentleman pulled into his driveway. The cops had been following him. He pulled into his driveway. The officer stopped the car. He got out and he backed the car. He was very intoxicated, and he backed the car and almost hit the police officer. Police officer arrested him, and the question was, well, could he be arrested for driving drunk in his driveway? We said yes over a dissent, and the people of Michigan were not happy with that. But the question we were asked was not, do you think it's okay for people to drive drunk on their own property in their own driveway? That was not the question we were being asked. The question we were being asked was, are driveways a place that is generally accessible to motor vehicles? Because the Michigan statute says you cannot drive intoxicated in any place that is generally accessible to motor vehicles. And so that is the kind of work that lawyers do, right? Judges ask these sorts of questions, not do you have an inherent right to drive drunk in your driveway, but is a driveway a place that is generally accessible to motor vehicles? That's a kind of roundabout way of saying that I think we need to have a different conversation about what it is we want our judges to do. Do we want judges to decide, yes, you have a right to drive drunk in your driveway, I can see the libertarian case for that, or do we want judges to pay close attention to things like text and history? And I think the public thinks that we do something different than what it is that we actually do in our jobs, and I wish there were a better way to communicate that. I have 6 pages of stuff that I didn't say, but I hope that was maybe a little more interesting.
That was great, particularly the drunk driving part. You clerk for Justice Scalia, and one of the cases that Judge Sutton points to as perhaps would have been better to have been handled in the state courts is the Heller opinion. And I'm wondering, because that's the Second Amendment opinion, and one could imagine that different parts of the country have different regulatory needs and different attitudes towards guns and carrying firearms. And is it fair to ask you what you think of that, and what you think maybe Justice Scalia might have thought of that as an approach?
Well, I mean, unless you're good, I mean, look, if somebody brings you a case based on the U.S. Constitution, and we have jurisdiction, you have to decide the question, and you have to decide the question based on the U.S. Constitution. I don't think there's an abstention doctrine that would allow us to say, well, we can just wait and see what the state courts say. If the U.S. Constitution protects that right, then it protects that right. Now, you can have a debate about whether Heller is right or wrong, and Justice Stevens and Justice Scalia had that debate, and I'm not going to rehash that one, but I don't know, under our current system, I don't know how the majority could have said, well, we're going to let that question play out in the states. If someone files the lawsuit, you have to take I mean, obviously, the Supreme Court doesn't have to take the case. They have that luxury that we don't have in our humble positions and on the courts. That is something I do miss about being on a state Supreme Court. We got to pick our cases, and being on an intermediate appellate court, you sometimes wish you had that same luxury, but we don't.
Thank you. So let's go to Colorado.
Let's go to Colorado. Actually, let's go to Colorado. It is a wonderful place, although I have to say today is a pretty nice day in DC, so good job. Yeah, and again, to echo Justice Liu, why are we all here? So let's talk about state constitutional law. I want to, though, begin by thanking David for putting this wonderful panel together. It's a real privilege to be here, and really thanking all of you for such serious attention to state constitutional law. Colorado is the home of state constitutional law. I don't know, do we have some Coloradans in the audience today? Yes, we've got Justice Mark, yeah. All right, wow, so you can attest to this. We have so much state constitutional law in Colorado. Our Constitution has been amended over 150 times since 1876. Yeah, that's right, thank you. That's a laugh line. I mean, that is amazing, isn't it? It is amazing that we have amended our Constitution so many times. And I want to begin really with thanking Judge Sutton for his focus on, that's such a general point, but it's so important, I think, when you live in a state like Colorado that has such an active state constitutional law system, and there's so much of it, and just to direct attention to that. And I tell my story about my poor intern from a law school not in Colorado, and we gave him an assignment, and he went away for a couple of weeks and came back with a wonderful, careful, thoughtful 20-page memo. But I had to tell him, I'm so sorry. 3 months ago, we just passed a constitutional amendment on this topic, and I have to throw this in the trash. And I think that's just a cautionary tale. When you're practicing law in a state like Colorado, you really have to start with state constitutional law. You just never know. And I think, as Justice Liu illustrated, you don't know what's going to be in the Colorado Constitution. My favorite provision is an amendment that bans public funding for the 1976 Olympics. Of course, that has to be in your state constitution forever, right? But I do think in states like Colorado, it's a place where people express their views, and you don't know what's going to end up in your Constitution, and that's why you really have to start with that. So I want to thank Judge Sutton for his serious attention to state constitutional law. And then I just have to start also where we left off, I guess, with our Duke panel when we did it, the dreaded lockstepping. And that's a term that Judge Sutton uses in his book, and he says, he describes it as a grave threat and the key impediment to his outlook, I guess. And essentially what lockstepping is, and we've talked and kind of danced around the point, but it's essentially where the state Supreme Court says, gosh, we are not going to interpret our state constitutional provision, which is analogous to the federal provision, differently unless you come up with a reason, a pretty good reason to do so. And I just want to read Colorado's version of lockstepping, and it's in a case called Curious Theater. This was a case, some of you may have heard of this before. We have in Colorado a statewide smoking ban, and the Curious Theater wanted to smoke on stage and basically said, smoking fake cigarettes on stage, that just doesn't do it. And you have to smoke real cigarettes to get your point across. So that was their claim, and the Colorado Supreme Court rejected that under the First Amendment. But I'll just read you the paragraph. Basically, this court is the final arbiter of the meaning of the Colorado Constitution, and as such, it is clearly within its power to determine that the state constitution places restrictions on legislative action even greater than those imposed by the federal government. So there's an acknowledgement first, I think, that the state court can differ. But then the court goes on to say, in the past we have, however, generally declined to construe the state constitution as imposing such greater restrictions in the absence of textual differences or some local circumstance or historical justification for doing so. So that's Judge Larsen's point. There has to be something different. Simply disagreeing with the United States Supreme Court about the meaning of the same or similar constitutional provision, even though we may have the power to do so, risks undermining confidence in the judicial process and the objective interpretation of constitutional and legislative enactments. So basically there, I think the court's saying, you've got to have some textual difference in order for the court to depart from that Supreme Court interpretation. So I just will end with this, that I think what Judge Sutton is proposing, essentially, hey, why aren't state courts doing this, right? I mean, that's kind of the question you pose. And I think the answer is, and it's the same answer I think that Judge Larsen gave, is there has to be a pretty good reason for doing so. And here we have, it's not just departing substantively in that area in precedent, but you're asking a court to depart from its own precedent about how it decides decisions. And I mean, this is, so it's kind of a double hurdle, I guess I would say, for Judge Sutton's approach. And I'll just throw that out there.
Well, so Jeff, it's going to come back to you here in a second. Well, could we talk about, maybe you could start with this lockstepping point, because that's pretty important to your thesis. Is you're trying to encourage the justices of the state courts to develop their own jurisprudence and not to be so influenced by the U.S. Supreme Court. So how does that actually work? So you're a trial judge in the state court, and somebody comes in, and let's say they take the two shots. So they say, shot number one is the federal Constitution, and let's say they win on that because there's a case. And you would say that this busy trial judge should also entertain the state constitutional argument, and maybe even actually have to have a trial about that. So I mean, that's a resource question of some magnitude, I think.
I'm getting ganged up on. I can feel it. I'm about to look behind me for another person. Yes, I get it. I get it 100%. So a couple ways to think about this. First of all, metaphors can slay. And our federal con law professors have been telling us forever that the federal Constitution sets a floor that no state actor can go beneath. Wrong, wrong, wrong. I truly want a free market of constitutional experimentation at the state courts. The state courts are just as free to go above the federal baseline in construing their own constitutions as they are to go below the federal baseline. A state court in Montana can say their free speech clause governs speech, not money, and therefore Citizens United does not control the meaning of the Montana free speech clause. Once they've done that, that's quite legit. In the other direction, a state can say our state Fourth Amendment search and seizure provision does not have an exclusionary rule. Very useful. There is one state in the country, well, New Hampshire, Maine do it pretty well, but there's no better state than Oregon. It took Oregon 15 years. There's an article that's been written about the Oregon experiments. It took 15 years for them to get the bench and bar focused on thinking about state law first. Think about it. Why, forget the Constitution for a second, why wouldn't you start on a statutory case with a state statute over a federal statute? Why would a state judge instinctively think, I'll construe the guarantee that goes beyond my borders? If I had a case about the meaning of French law in an Ohio statute, wouldn't I start with the Ohio statute if that might resolve the case? Of course you would. Now there's no doubt, this is why it took Oregon 15 years. Of course, when you've got a case where the U.S. Supreme Court precedent answers it, the busy trial judge just gives it the back of the hand. I have no objection to that, of course. I'm not crazy, I'm not insane. That's a joke. You guys are looking way too seriously. No, I think it's a close call. They're saying it's a close call. It's crazy, insane, it's close. First of all, this is just a pure orientation problem, and what Oregon did to its credit is they realized the only way you would get us out of this gravitational pull from federal con law was straight up immersion. It's just learning a new language, and you had to if you wanted to bring two claims, you had to bring the state claim first, and Oregon was going to deal with it first before it got to the federal constitutional claim. Now, I think they would have exceptions, as I think other state courts should have exceptions for. Fine. If there's a federal claim that really takes care of it, great. Maybe they'll just bring the federal claim. That's point one. Point two, let's not get lost on something here or not lose track of something. If the U.S. Supreme Court puts up a stop sign, there is no other shot. All right? You can just, if you like being unhappy, you can do that. But when the U.S. Supreme Court says no to the federal claim, there is no other shot. That is the most important area for us to be talking about. All right? Warren Buffett has this great line about hedging your bets on investments. States that hedge their bets pay attention to the state and the federal constitutional guarantees. In the words of Warren Buffett, tides come in and tides go out. Rights go up, rights go down. Paying attention to state constitutional law, in the words of Warren Buffett, is like you determine who's got their bathing suit on when the tide goes out. Oregon has its bathing suit on. The rest of the states do not. All right, that's the whole point here. That's the marriage story. 1972, U.S. Supreme Court stop sign. There is no 14th Amendment right to same-sex marriage. 9-0 decision, summary affirmance. The only activity possible was through the states. And this also brings up this just question of what do we want? This is a reform point. The ALI is a reform organization. What do we want for the way we recognize and identify rights? And I ask you to compare the Roe and Obergefell stories. Roe is a story we are still dealing with because of the race to Washington for the winner-take-all victory for my side of the debate. Obergefell, it strikes me, I'm not allowed to make predictions as a federal judge, but it strikes me as very unlikely that that's a decision. I don't know that there's a single justice that would consider overruling that decision. Why? One should ask oneself. They're both controversial decisions. They're both at the edges of judicial competence. Why is one more settled than another? Is it possible that because what happened there was the states laid the groundwork, slowly to be sure, and there's all kinds of debates about pacing. There's even debates about Obergefell itself in 2015. But we have to ask ourselves, how do we want to do this? And I'm fine with the winner take all, but please don't cry when after you get your winner take all, you get just what you want, you get to not only tell the people of Ohio what you want, but the people of California, Arkansas, Colorado, etc. And then don't be shocked when they return the favor and they say, I got that playbook, I know how to use it, I'm gonna go do the exact same thing and do to you what you did to me. So we get to choose. We can either develop this from the ground up, pay attention to local lawmaking through statutes, state courts, regulations, I don't care, or we can race to Washington, but if you race to Washington, the American people aren't fools. You're gonna win half, and you're gonna lose half, and you're eventually gonna find yourself living in a country where 5 members of a 9-member court have the biggest say over the biggest issues in the country. If we want that, that's what we get. I don't think it's a great path, and I think it will end in tears.
But eventually the court would do
And that proves lockstepping's bad.
Could I add a thought? So now I know the first line of my next constitutional decision, which is, I got my bathing suit on. That's one thing I'll take away from this panel. So I think what Jeff set forth first as mystery number 3, this question of why it is that state judges don't do this, and instead defer to lockstepping, as my colleagues have discussed it, is probably, in my view, the biggest mystery. That is the biggest mystery. And it's a mystery because it's not an intellectual problem in the sense that, of course, every state judge who has to deal with these materials acknowledges and realizes that in the federal system, they do have this prerogative to interpret their state constitutions independently. And so the question is, why don't they exercise this obvious prerogative? So I've puzzled over this for quite some time, and actually I would be very interested in everyone's views about this, and I think this is actually an area in which ALI could do some very interesting exploration because it goes very much to the heart of the structure of government. Why this aberration? Part of it, I think, is a sociological proposition about judges. Judges are cautious people by nature. That's part of the professional norm, is caution. And so when I describe this issue, I often say it's like the apocryphal story of the person looking for their car keys in a dark parking lot at night. And they're looking under a street lamp. Passerby says, oh, did you lose your car keys over here? And the person says, no, but the light is better over here, right? Judges go to where the law is, right? They go to where the law is because that is their professional MO. Where there is law, that's where they go. And it just so happens that in a lot of big swaths of doctrine, the U.S. Supreme Court is very voluminous in terms of what it has said. And that's where state judges go because there is law. That's one proposition. Another proposition is that we have been raised to believe this goes to the quote that Judge Ide read, the determinate, objective meaning of constitutional provisions. Now, we don't have to debate legal realism or any of these bigger propositions here, but all I will say is the more limited point that objectivity in constitutional interpretation is in some tension with the constitutional design insofar as we think of the constitutional design as permitting multiple interpreters of the Constitution. Pluralism is all over the place in the American Constitution, precisely because, as Madison told us, the whole point of it was to disperse power to multiple centers so that no one entity would hold everything in their grip. So it's not just between state and federal courts, it's also, as we see playing out right here in this city, the debate between the executive and the legislature and the judiciary about the meaning of the Constitution. Going through all kinds of interpretive forums with no one entity necessarily holding the upper hand at all times. This is a structural feature of our design, and it is not, it coexists with what we tell ourselves about the objective determinate meaning of the Constitution. It is no more indeterminate to talk about the Constitution having possibly, people having different views of it, than when the US Supreme Court divides 6-3, 5-4, whatever, on a particular constitutional issue. That does not subvert the objectivity of the interpretive enterprise. It just means some questions are hard, and they're susceptible to different reasonable resolutions, and our constitutional design permits the expression of these reasonable interpretations instead of, as Jeff says, a winner-take-all system where there's only one answer for everyone settled for all time.
Great. Well, we are under the light, but I'm not going to call on our panelists any longer. We'll call on you, but it's hard to see you because of the light. So just raise your hand and be a bit aggressive and ask your question or make your comment. Okay, here we go. Okay, did you hear that?
I did. Well, I mean, are you shocked?
Maybe you should repeat the question.
Okay, so the question is whether with the state constitutional law being developed, will we end up with red state, blue state constitutions?
That risk exists. It really cuts to the uniformity point, and it really cuts to a basic American value that things we think of as constitutional rights, like the right not to be excluded from something based on your race or faith, ought to be protected everywhere. So that's a real, we start with that instinct. The thing I'm trying to say is that, yes, there are many times where we should have no red-blue state phenomenon at all. They really are national rights. They're right there. But the map story is so fascinating on this point. If you want to ask yourself the central impetus of MAP, it was to have a uniform exclusionary rule with this uniform meaning of the Fourth Amendment for the whole country. It got rid of the silver platter doctrine and a bunch of these abuses. It just didn't seem right to have different rules for exclusion in one state versus another, or federal government versus state. So the whole idea was to unify Fourth Amendment law in 1961. The punchline of that story is search and seizure law and exclusionary rule law is more disuniform today than before 1961. In 61, the US Supreme Court was pulling uniformity up to be more rights protective, and everybody forgot the point that what goes up can come down. And what has happened since 1961 is the disuniformity is created by the states filling gaps in the exclusionary rule created by the US Supreme Court, or the states filling gaps in the meaning of the Fourth Amendment where the US Supreme Court has not recognized the right. So I guess you can call it blue state, red state. I will say, this is, I guess, the best way to alleviate a little bit this anxiety. I've probably read 500 state Supreme Court decisions where the state court did something different from the US Supreme Court. The common denominator is not blue-red, Republican, Democrat, living constitutionalist, originalist. The common denominator is state courts finding something interesting, unique about their history, their culture, or the text of that state constitution. So I actually think vibrant state constitutionalism is going to reflect the history and traditions of those states, which isn't necessarily red-blue.
Yes.
Thank you. I have a question for Lou. I'm wondering why state judges don't do more. Would you put the blame perhaps on law school? They don't learn about it.
Okay, so the question is, what about the law schools?
I put the blame on myself. After I read Jeff's book, I had to look at my own syllabus, which I taught from for 10 years. And it's true, there are no state decisions on the syllabus because I track most textbooks in this area, which also don't have such things. So yes, I think that to the extent that we're talking about aspects of professional culture, not about hard knowledge about, the fact that we know that this prerogative exists and the federal system is designed the way it is, but rather about culture and how we think of, the way of reasoning through decisions and where we look to for sources of law. Yes, I do think that legal education bears part of the responsibility here, but it goes beyond that. It goes beyond that, and that's why I think this is such a valuable forum and topic for ALI to take on too.
So I think I have an answer partially to the question of why these cases are all on federal law, and that is just think about the Alabama abortion statute that was just enacted. Think about two things. Number one, if you're the lawyer representing somebody who's a doctor, for example, or a patient, if you go to the state court, you're almost certain to lose, and your client may be adversely affected, but you have a much better chance in the federal court. If you go to the federal court and add a state constitutional claim, the Supreme Court has made it very clear that the federal courts don't have jurisdiction to decide the meaning of state constitutions. So
Wait, that can't be right. My court just did it. I mean, I dissented, so if you have a case for me, gosh, I wish I had known that, but
case, Alderman, it is out of Pennsylvania a couple years ago, in which they said that you couldn't decide what the meaning of the state constitution was. What's the federal question? Certainly the U.S. Supreme Court can't decide it.
well, it was a diversity case.
No,
Diversification couldn't decide.
All right, so they did. I mean,
no, it's constitutional challenges. So if it's a constitutional challenge to a state law, the 11th Amendment interferes. If it's a constitutional challenge under the state constitution to a local law, no 11th Amendment. So you're quite right. There is that limit as to why there aren't two shots in federal court. That doesn't apply, that of course doesn't apply in state court, and you're exactly right that in some states, if the politics are such where the state court judges are going to be very similar to the state legislators, the idea of the state constitutional shot being that meaningful doesn't make a lot of sense, and the idea that the state court judges may not be very helpful. That's quite understandable. As a matter of strategy, that surely can play out that way. But that's not going to be true everywhere.
Yes.
So, Judge Sutton in Madison, Wisconsin, where I live, we know well that when Justice Brandeis was talking about the laboratories of democracy, he was talking about the highly functional Wisconsin government in the first third of the 20th century. But what I worry about is this. My parents didn't grow up in Wisconsin. They grew up as sharecroppers in Mississippi. And I worry that when you have percolating laboratories of democracy, those people who need their rights vindicated the most are those who wait the longest for their rights to be vindicated.
Yeah, so the pacing of American constitutional law is the big question. I can make it harder. Let's talk about the pacing of American constitutional law with respect to capital punishment. That has been a very slow slog. People have gotten executed in the interim. Executed, that's that. One does not know how this story is going to end. If it ends with nationalizing a rule against capital punishment, you can see someone saying, why did it take so long? But you can never ask that question by itself. This is our problem, without asking about the risk of backlash and undermining the very rights you're trying to take care of by doing something too quickly or without either the right thinking or without paying attention to all the unintended consequences. The whole point of the MAP chapter is this provocative question. Did criminal defendants lose more by winning MAP? That's the question. So that's what I want everyone asking, and if you have a good answer, nationalize by all means. But you better have a good answer, and don't be wrong, because there are lots of chapters in American history where we've been wrong, and a lot of people have suffered by prematurely, too quickly nationalizing the right. In fact, we just had a presidential election that arguably turned on a sufficient number of Americans choosing a president as a proxy to fill one seat on a 9-member court. There's a little bit of backlash going on.
Somebody over here? Yes.
I'm interested in your tides go in and tides go out, recognizing that at any given time, the U.S. Supreme Court's interpretation of the federal Constitution kind of puts a stop on it. So the U.S. Supreme Court has decided Citizens United. The U.S. Supreme Court has said that campaign finance is speech and is therefore protected. Justice of these cases. You're suggesting
Yeah, it's a wonderful question. Two things. One, you eliminate the possibility of any state claims, so you say out of the box, you don't have to worry about this because the state constitution doesn't protect it. That's useful. And any state that does state law first would always do the state constitutional guarantee no matter what. So that's point number one and two. Here's the broader point and the real answer to your question. My example of Montana is actually a real case, happened in 2011. Let's imagine if the Montana Supreme Court, which decided simply not to follow Citizens United under the First Amendment and got summarily reversed 9-0. Let's imagine the Montana Supreme Court does what I think is right and what Oregon does. They first address the state con law issue. They explain why their constitution protects speech, not money, the history of the copper barons in Montana, and so forth, and some very good reasons for the state constitution not covering money and opposed to just speech. Now you say, Jeff, what good does that do as long as Citizens United is still on the books? Well, I take it from your question you'd rather not have Citizens United on the books. And if that's true, it would be very helpful indeed to have quite a few state courts disagree with Citizens United in construing their own constitutions. Citizens United is not an originalist decision. It could be a decision written by an originalist state court that explains why, as an original matter, it doesn't make sense. Is it not possible that could get the attention of some of the 5 members that were in the majority? They could write an opinion that is norm-shifting, living constitutionalist, pragmatic. If the Montana Supreme Court had done that in 2011, I can almost guarantee you'd have 5 to 10, if not 15, progressive state courts in this country doing exactly the same thing. That is meaningful if one does not like Citizens United. Now, I'm not taking a stand on that. The whole point of this is to try to be perfectly neutral. That's why Brennan and Scalia both embraced it. But it would not be a meaningless gesture, and the only way it's meaningless is if you like Citizens United. But if you don't care for Citizens United, it would be laying some data points as to perhaps why it should be reconsidered. And that can go with conservative rulings and liberal rulings.
Yeah.
No, go.
Yep.
No, I defer
Yep.
to you.
Good. Yes.
That means you have to have one of the parties not raise a federal question, correct?
No, you could, the 2 shots. You can raise 2 shots.
Montana Supreme Court decided based on that constitutional provision, there was a recent provision in Oregon, in Montana, to specifically respond to minority politics. Right? That's the issue. Then recognized its say summarily reversed it. Reversed it to most insulting terms. Essentially saying, can't you read the federal constitution for this woman? Somebody's got to raise a federal question.
So maybe I'm misunderstanding something, but let me tell you what I understood happened. I did not understand the 2011 decision of the Montana Supreme Court to be about a recently enacted constitutional provision. I understood it to be about their general free speech guarantee, as well as there's a federal, of course, free speech guarantee. What the Montana Supreme Court did as a mistake was suffer from Stockholm Syndrome and think the only game in town was the federal free speech clause. The only game in town that mattered was to explain why Citizens United couldn't possibly apply in Montana given its history, and to properly get summarily reversed because the supremacy clause requires the free speech clause to mean the same everywhere. What they should have done is started their analysis the way Oregon does, explain why there are 2 free speech clauses govern. There are 2 free speech clauses that govern this law. We'll start with the Montana one, and the Montana one governs speech and not money. Having done that, in one sentence, they could say, so long as Citizens United is good law in construing the federal free speech guarantee, we must invalidate this limitation on corporate spending. And that would have been a 1-sentence analysis, but the first point would have done everything they did. I mean, the amazing thing about this case is they wanted to do what I'm suggesting, they didn't know how to do it. Well, I should point that out. God only knows how it was briefed. That's a great point. Well, yeah, so let's forget the 2011 case. I think Carol's point is a really good one. Jeff, how is this is like just so academic and impractical. Why are you saying this? And I'm saying it is practical. It's incredibly important for the state courts to express their disagreement going up or down when it comes to federal constitutional rulings if they think they do not respect the meaning of their own guarantees that they have the final sovereign say over.
Yes.
One of your first points was the fact that you were very close to having a one-sided vote
Perfectly partisan vote, you're right.
in the United States Supreme Court. But I'm not sure that moving some of these questions to the state level is going to be a solution. Definitely it would disaggregate the decision. But in the state Supreme Courts now, especially in the last 4 decades at least, more and more it seems that special interests are understanding the importance of state Supreme Court justices and putting their money and muscle into state Supreme Court elections to tilt the balance.
You're 100% right. And
I think the real basic problem that we have, societal problem we have, is how are we going to maintain the independence of the courts so that we still have checks and balances in our system, which are rapidly being eroded. If the United States Supreme Court reverses Roe v. Wade in the next several years, that's going to move them into the political realm completely. And I think they're going to suffer an enormous amount of loss of credibility as an independent institution.
you're,
Same thing happening on the state level in a number of jurisdictions. So
well, the short answer, I think Judge Larsen was hinting at this before. The more power courts of any stripe, state or federal, exercise, the more the people are going to care who are in those courts. The book I really believe in is not the book I wrote. The book I really believe in is that judicially enforceable rights are overrated, and that the real aim in this culture and in this society, in every state, in our national society, is to create a culture in which the majority looks after the minority through the democratic process. That's what I really believe in. But as I said at the outset, this country believes in judicially enforceable rights, and as long as that's true, I think it's foolish and unfair to be upset that the American people want to say who are in those courts. And as between politicized federal or state, I'd rather have the politicization at the local level, because that way there's more control locally over either changing the Constitution with a 51% vote or changing the composition. So you're giving me the choice of two bad things at the end, and I prefer the politicizing at the local level where the people have more control. If they're going to exercise a lot of power, it's darn right fair that the people ought to have a, quote, political say over who's on that court.
Well, we're going to have to leave it there. Maybe, Jeff, it's a very good book, but maybe it's an imperfect solution. We actually have 52 imperfect solutions, but we have a perfect panel to discuss it and a perfect audience. Thank you very much.